Following marriage, parties can separate, of course, at any time. However, parties must have been married for at least 12 months before they can start divorce proceedings. That means that a divorce petition can't be issued with the court until the first anniversary of the marriage has passed.
The timescale really depends on how the parties react with each other. At the Law House, we try to complete a divorce process within about 5 to 6 months, but this does depend on whether or not we can get the divorce proceedings served on the other person quite easily and whether they are going to be cooperative when they receive the divorce papers. But usually a divorce process can normally be finalised between about 5 to 6 months. It's not always necessary to go to court, and in fact in most cases parties don't have to go to court at all during the divorce process. It may only be necessary to go to court, for example, if you're a respondent in the divorce proceedings and you're objecting to something that was put in the divorce petition, such as if your ex-wife or husband is asking for you to pay costs. So for the actual divorce process, usually we can deal with that just by dealing with paperwork. It might be necessary to go to court at a later stage if, for example, there's a dispute over finances. But usually for the actual divorce process, it's not necessary to have to go to court. It doesn't really matter where the parties live, as long as they were habitually resident in England and Wales at the time that they were married. So if one party is actually moved abroad, that shouldn't make a difference. But what we do need to know is where that party lives, so that we can serve the divorce petition on that person without having proof that that person has received the divorce petition. You can't actually move on to the next stage of the divorce proceedings. So from that point of view, it is necessary to know the location and the address of the person, but whether or not they live abroad is really irrelevant to the divorce proceedings. It's not enough to say that the marriage has broken down and parties don't get on with each other. They have to rely on one of 5 statutory grounds in order to show that the marriage has broken down. Very quickly, those are that you claim that the other person has committed adultery, or that they have acted unreasonably, their behaviour has been unreasonable. The third ground is if you claim that the other person has deserted you, but that's quite a rare ground and is very rarely used in court proceedings. The fourth ground is where the parties have been separated for 2 years and both parties consent to the divorce. And the fifth ground is where the parties have been separated for 5 years, but you don't have to get the consent of the other person in order to get the divorce.